Your house is probably the most valuable thing you own. If you die without a will, a court decides who gets it. Not you, not your family. A judge following a formula written in 1950. And that formula may hand your home to someone you never intended. In the next 6 minutes, I'm going to show you exactly what happens to your home and everything else you own when someone dies without a will. What the law does automatically. Who ends up with what? And the one document that changes everything. Dying without a will, the default system. When someone dies without a will, the legal term is dying intestate. In the auditing world, we call this the default system. Intestate means there is no manual, no instructions, and no named beneficiaries. When you don't leave a blueprint, the state assumes you wanted their plan. Every state has a set of laws called intestate succession laws. These aren't suggestions. They are rigid mathematical formulas that decide exactly who inherits your assets. Here is the cold reality. These laws don't care about your intent. They don't care if you told your daughter she could have the house because she took care of you for a decade. They don't care about handwritten notes on the fridge or verbal promises made at Thanksgiving. The court only recognizes what is legally recorded. If there is no will, the court falls back on a bloodline hierarchy that hasn't changed in generations. The priority audit, who gets what? Intestate succession follows a strict priority order. The court starts at the top of the family tree and works its way down until it finds a living person to hand the keys to. In most jurisdictions, the order looks like this. The spouse usually gets the first share, but rarely all of it if there are children. Children, they split the remainder equally, regardless of their relationship with you. Parents, they only inherit if there is no surviving spouse or children. Siblings, next in line if the parents are gone. But here is where the math gets dangerous for your home. Most people assume their spouse gets 100% of the estate. That is a myth. In many states, if you have adult children, the law mandates a split. Often the spouse gets 1/3 and the children split the remaining 2/3. Imagine an Ohio family. The husband dies without a will. The wife assumes the house is hers. But under Ohio's intestate formula, she only owns 33% of the equity. Her 3 adult children now legally own 66% of her home. If just one of those children is in debt, facing a divorce, or simply wants their share of the cash, they can force a partition sale. The wife, the person who lived there for 30 years, cannot stop it. This is how default laws destroy legacies. The deed audit, tickling versus the court. Your home doesn't pass to your spouse automatically just because they live there. It all comes down to the deed. As an auditor, this is the first place I look. If the home is titled in your name only, it is probate bound. The moment you pass, the court places a legal lock on that property. No one can sell it, no one can refinance it, and in some cases the family can't even change the locks without court permission. In states with backlogged courts like California or Florida, your house could sit in probate limbo for 18 months while the meter runs on attorney fees. If the home is titled jointly, you might think you're safe, but you need to check your deed for 5 specific words. Joint tenants with right of survivorship. If your deed simply says joint tenants or tenants in common, your half of the house still goes to probate. Your spouse ends up co-owning the house with your estate, and that means the court is back in your living room. And for the unmarried, if you've shared a home with a partner for 20 years, but your name is the only one on the deed, the law treats your partner as a stranger. The moment you pass, your partner could be legally evicted by your next of kin, siblings or parents you haven't spoken to in years, because they are the legal heirs and your partner isn't. The full blind spots of the law. The default system was built for the 1950s nuclear family. It fails miserably for modern families. There are 4 specific situations the law gets wrong every single time. Blended families, stepchildren have 0 legal standing under intestate law. If you raised your stepson since he was 2, but never legally adopted him, he gets nothing. Your biological children inherit everything. Unmarried partners, as we discussed, Common law marriage is a myth in most states. No marriage certificate means no inheritance rights to the house. If you have an estranged child you haven't seen in 2 decades, they are legally entitled to the exact same share as the child who cared for you every day. Friends and charities. You cannot leave your home to a church, a non-profit, or a lifelong friend without a will. The law only recognizes blood and marriage. The manual override. Every tragedy I just described is 100% preventable. A will is your manual override of the government's default plan. A will allows you to name exactly who gets the house. It allows you to protect a partner, include stepchildren, or exclude a relative who doesn't deserve the inheritance. Most importantly, it names an executor, someone you trust to manage the property so it doesn't sit vacant and rotting while the court argues over who is in charge. A basic, professional will typically costs between $300 and $600. Compared to the $20,000 to $40,000 your family will spend in probate fees if you die intestate, it is the best investment you will ever make. Let's wrap this audit. If you die without a will, you aren't leaving your family a home, you're leaving them a legal battle. The state follows a formula that doesn't know your name and doesn't care about your wishes. A will takes a few hours to complete and puts the power back in your hands. It ensures the person living in that house stays in that house. In the next video, I'm going to audit the 5 most common will mistakes that make the document worthless even after you've paid a lawyer to sign it. If you already have a will, you need to watch that one to ensure your override actually works. Hit subscribe so you don't miss that audit.